Hello, welcome to the Vercammen Law of Civil podcast. This week, we're talking about the probating of a will in Union County, New Jersey, through the Union County Surrogate's office. So, each county in New Jersey has a surrogate's office, and the county's surrogate has their own information sheet, and it varies from county to county. So, typically what we as the attorneys try to do is type up the information ahead of time to help the surrogate, email it to the surrogate, or fax it to them together with a copy of the death certificate and a copy of the will. If everything is good and the will is a self-proving will, then the person can typically make an appointment to see the surrogate to bring in the original will, original death certificate, and a check. So what's some of the information that's required? Well, number one, they want a death certificate because was the person who passed away a resident of that county? If the death certificate says they're a resident of somewhere else, then they have to go to that county. Sometimes the death certificate is wrong because it's not based upon where the person what hospital they might have died in, but where they were living. Okay, so next we got to type in the executor's name, their cell phone number, their address. Okay, was there a will? Because if there's no will, it's called an administration. That becomes much more complicated. What's the date of the will? How many pages is the will? Let's see, the person who passed away. Let's see, what's their date of birth, the date of the will, the date of death, what's their social security number, were they married, widowed, or what was their status? And interestingly, some counties require the social security number of the executor, most do not. What's the address? The address of the executor has to be typed in, and their cell phone number. I try to include their email. Got to type in what's the next of kin and who inherits under the will, and if there's any minor children, the age of the minors, not just children, minors that are inheriting under the will. We need to advise the surrogate how many what's called certificates are needed, shorts. We also call them letters testamentary. For the initial paper. The name and address and email of the attorney should be provided. If there was a trust established under the will, then the name of the trustee has to be provided, and that person's phone number, etc. So wills sometimes have a provision that if a minor's inheriting money, there's a trustee. Oftentimes the trustee would also be the same person as the executor, and when there's trust, then the more information needs to be provided. But New Jersey, on the other hand, is a probate easy state, and as long as the will is a self-proving will, then admitting the will to probate is not a complicated process. For more information on admitting a will to probate, visit website njlaws.com, and for assistance or representation in the probate process, contact Ken Vercammen's office at 732-572-0500. Thank you for watching.